As well as the standard fair use policy, these videos are protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Islam Moorish.
My nationality is Moorish.
We got him squared away. All right, so Mr. Hudson Bay, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay. And knowing that you still wish to go forward on your motion today representing yourself? You want to go forward representing yourself today, recognizing the court has to hold you to the same rules?
Yes.
Okay, very good. All right. All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bay's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily.
This man's request to represent himself was definitely done knowingly, but to say that it was done intelligently is a stretch, because any intelligent person is not going to try and represent themselves. It's just that simple.
It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bay has been in this courtroom. Has been numerous. His answers have always remained the same. With his desire to represent himself, he's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bay, and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bay, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me. Pain. I'm coming. Yeah, I'm coming. I'm just gonna read my motion.
Do you guys see this? Do you see how nervous this man is? Just from that, I already know this man is about to make the most ridiculous speech that we probably have ever heard come out of a sovereign citizen's mouth. I can't believe that this man really is coming off this nervous. And all he's about to do is probably read something off a paper that he printed from the internet.
Pain. I'm coming. Yeah, I'm coming. I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bay, in aforementioned case with a motion to stay. Defendant move for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injuries to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellant's ability to present a robust defense. Denial of continuance. The defendant appellant motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellant's rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellee. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence would cause irreversible harm to defendant's appellee, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request stay will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellant rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond or, in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court's filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you. Yeah.
Wow, that was a mouthful, and I have no idea what that man was trying to get at. So let's see what the judge now has to say about his ridiculous speech.
Thank you. Yeah.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, not identical to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed, in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would estimate that deny the defense now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 2004. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time, and then a January 26 order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bay has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor that it's been. Hold on, sir. Let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file whether they have or haven't, and it does not impact the court's decision regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bay filed earlier, this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bay is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, motions and anything that occurred prior to that date can be reviewed then. And he'd have an appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bay, I'm going to deny the request for a stay here today.
So pretty much this Moorish sovereign citizen's motion is denied because he has no idea what he's doing. He's filing things out of order. He's filing things that should only be filed after the courts have made the decision. He has no idea what he's doing, which is why his silly behind should hire a lawyer.
Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bay has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bay has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet, and I don't have any information saying that the Michigan Supreme Court denied anything, because
well, that's what I said. I don't have anything either. But so here's the thing: I'm denying the request today. Now the Supreme Court, if they sign an order that says, "Wait, we're granting your request for a stay," then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything. The date that I filed.
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
okay.
The case title is TBD. I assume to be determined. Yes. So that is in the file. It's received on February 9th.
Yeah, I can't do nothing until I get those transcripts though. Okay.
So next order of business then is Ms. Bond is here. We had a pre-sentence report completed.
No, not yet. He's scheduled for sentencing on March.
Okay. Does he have a date that he's to report to?
I'm going to actually make contact with him this afternoon.
All right. So Mr. Hensley Bay, absent some direction from the appellate courts, it sounds like probation will be contacting you to begin the process of completing the pre-sentence report. And what was our sentencing date?
March 5th.
So March 5th looks like will be our sentencing date. Okay. So make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're going to be reaching out to you to get that scheduled and get a sentencing date. Okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley.
All right. I come today and get that order that denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office. And you are certainly welcome then to contact the clerk's office for a copy so that you have it for your records.
Okay, gratitude.
Okay, sir, you're all set today. Thank you.
All right.
What do we have next?